For hearing, question number 3 of between the Republic of Somalia and Mohamed Ahmed Awil, Ali Abdul Nur Osman, Abdullah Mohamed Ahmed, and the Secretary General of the Southern Community.
Yes, good morning. Council, can we get the introduction from the Attorney General?
And Happy New Year. All right, thoughts? My name is Hanif Panamol, advocate, High Court of Defense. My Lord, in court, and all representatives from the Federal Republic of Somalia, please allow me to repeat the court. The first one is Mohamed.
Recording in progress.
Mohamed Abdullahi Hassan, who is the senior whip of the House of the People. The second one is Honorable Mahdi Mohamed Gulaid, who is Member of Parliament of the House of the People and also the former Deputy Prime Minister. The third is Mohamed Ibrahim Ali, Honorable Member of Parliament, House of the People, and Member of the House Leadership Committee. And Mr. or rather Honorable Abdul Salam Omar, Presidential Envoy to EAC and former Foreign Affairs Minister. We also have Abdirahman Mohamed Abdullah, who is the Permanent Secretary of the House of the People. And finally, we have Lieutenant Colonel Abdul Fattah, who is the Defense Liaison Officer of the Federal Republic of Somalia at the EAC. That's all, my lord.
To introduce the conflict that you cannot even introduce the other party.
He's my senior.
Yes.
But I will introduce him. I thought his class were in court. I didn't have the full details. But representing the respondent is His Worship, Honorable Yusnali Sokuna, Bernard Senior Advocate from the Republic.
I do say His Worship.
By virtue of the position he occupied in this court as the registrar, he remains His Worship before our eyes.
Yeah, that is before your eyes. That is before your eyes, but I think before the court.
Council.
Yeah, it's a council.
Thank you.
I think there's no problem, Mr. O.
I have no objection.
Yeah, I think it's okay. Let us not retain our previous positions because, but it's okay. So, I think let us make this clarification today before we begin. First of all, let also me wish you a happy New Year from the Federal Republic of Somalia and the people of Somalia, but also the people of East Africa. So that at least our New Year be a prosperous and also a peaceful year. Yeah. So this is our first session for this year. And we hope this session will be also smooth. But this is our first session. That's one. Secondly, it is not our ordinary session. It is almost an extraordinary session because we are not sitting in January. So that is also for the record. And to clarify that we are not coming for the appeal. I know sometimes the council, when you are here, you try to go around. So we have come only for the application. So let us argue our application, not the appeal. Yeah, it is the application, not the appeal. Maybe how long Council for the Federal Republic, because we are not coming also for lecturing us. You argue your case. How long do you think suffices for you?
Thank you, my lord. I'll try to confine myself in under 20 minutes.
Mr. Okubo.
My lords, first of all, thank you for accepting to sit in this extraordinary session as the matter was filed under certificate. I'll take no more than 15 minutes.
Thank you. But you are also saying it is not urgent. When we read your affidavit reply, you say there is nothing urgent.
Yes, I'll come to that, my lord.
Okay. Yeah. Mr. Amo.
Thank you. My lord, we should reply now that for purposes of today, the Attorney General has placed before you 2 bundles of documents. One is the bundle dated 27th November, that's when it was lodged, 25, which is titled Application and Supporting Affidavit. And there's a second bundle, which was filed in court yesterday, titled Skeleton Submissions and Authorities. So we will be making reference to those 2 documents this morning. My lord, my lady, what's coming up today is the Attorney General's application dated 26th of November 2025. And the application is made under Rule 86 and 87 of the court's rule. And it's essentially seeks an order to stay execution of the injunction issued last year by the appellate, by the first instance division. My lord, if we look at the rules, Section 1 gives the honorable judges the warrants to stay proceedings or decree or order of the first instance division if there is sufficient cause for ordering stay of execution. The court has powers if there is sufficient cause. When you go through sub-rule 3, the rules break down what the court should look at when exercising that power under Rule 87(1) of stay. 1, the court should be satisfied that a substantial loss may result to the applicant, in this case, to the Attorney General of the Federal Republic of Somalia, if stay is not granted. Secondly, the court should satisfy itself that the application has been made without unreasonable delay. Thirdly, that security has been given by the applicant for due performance of the order which is being challenged, if that is required. And of course, even a single judge of the court could, on ex parte basis, hear such an application and give interim order of stay. I was just trying to highlight basically the context in which our application is made and what we'll be expecting the court to clarify on, to ask questions on, and to hear as to whether that particular application meets the expectations set out under Rule 87. In summary, my lord, the first instance division made a decision which essentially stopped members of parliament who were elected by the National Assembly of the Federal Republic of Somalia on 15th of October 2025 from assuming their seats.
Are they already a member of parliament?
Yes, my lord. Upon election, they became members of parliament.
So when they are elected in Somalia,
by the national,
they become member of EALA.
Yes, and that is, you find that guidance.
Suppose, for example, one member of parliament, one elected individual, because I saw the first it says individuals, not member of parliament. Suppose before coming here in Arusha, one of them person,
Yes.
will he be catered for by the community as a member of parliament?
I think you, my lord, is inquiring whether he will be enjoying the privileges of a member of parliament of Yala if he passes on before he assumed the seat at Yala. Of course, my understanding that is no, because at that time he has not reported for duties. But has he been elected? Yes. Thank you. So, my lord, when that decision was made, and the decision has been placed before you, the judges, the honorable judges of the First Instance Division, relied on some facts which are obviously contentious, but they should not have been. One of those facts is that they were persuaded that even though an exercise in the National Assembly, that is not contested, that the people who were elected were predominantly from an allegedly ruling party called Justice and Solidarity Party. My lords, when you look at the application that was placed before the judges of the First Instance, there is no reference to such a ruling party as Justice and Solidarity Party. In fact, the reference is to the fact that there is no single parliamentary party in the Federal Republic of Somalia, meaning there is no ruling party, there are no opposition parties in the current architects of the Parliament of the Federal Republic of Somalia. Instead, members of Parliament are elected on the basis of what we call the 4.5 formula, the Garowe principle, which is clan-based. So what ought to be looked at is, are representative of that formula, they represent the 4.5 clan. And the facts that were placed before the judges were that that was the representation. It was not contested. That indeed, the 4.5 formula was fulfilled in this particular election. So one of the bases of the decision which we are challenging on appeal and which we are seeking to stay now was that the list was skewed in favor of the ruling party, which is non-existent. That patently shows it was a decision based on an erroneous fact, a fact which could not be ascertained from the pleadings that were before the court. And the very first question I'll be posing, my lord, is, would you as the appellate division allow a decision based on a prima facie wrong facts stand, cause an injustice, and wait for that reference to be applied with all the hardship and the irreversible damages, the irreversible harm it's causing, that will demonstrate with the next thing. My lord, when the matter came up, obviously the Attorney General argued that elections have taken place and the complainants have an opportunity to contest the outcome of the elections through the courts in Somalia, or even the Somalia Electoral Commission, which is provided for in the Constitution. And that reliance was placed on Article 52, which leaves such matters to be determined. Article 52 of the treaty, such matters about the outcome of elections to be settled using domestic procedures. Of course, one question will be arising, and I'm very certain my learned senior will be raising it. The judges themselves may be thinking about it. The reference is before the court. Do we strike out the reference and let them go back to the national courts? What happens if the court proceeds and hears the reference and determines that, in fact, these members who are not validly elected. By that time, if they've already taken oath of office, does it mean then the first instance can recall them from their oath of office and call for fresh elections? The current jurisprudence is that those members cannot be recalled by the court. Certainly, there's no single case that has tested that, but there have been orbital proclamations by the court at the first instance. I have not seen any single decision by the appellate division on that, because that question has not surfaced. But in suits of this nature or application, there has always been at preliminary stage an argument that you cannot unswear members of parliament who have been sworn in. And you will also see it in the ruling that we've challenged. Certainly, we do not believe, as the Attorney General, that that is the position. And we will state our reason. We believe that members who are not validly in office or whose questions, or at a later stage, are validly considered tribunal determines that they are not valid in office or they ought to vacate office, can leave.
Maybe, Council.
Yes.
Is there any provision of the treaty that forbids the elected individuals to come directly to this court? Are you referring to Article 52? That those individuals could not come directly to this court unless they have finished within the internal institutions in Somalia?
Yes, my lord. I'm referring to Article 52 to say that the matter, the court assumed jurisdiction erroneously and made an order before letting an inquiry be made under Article 52. And if an inquiry is made under Article 52, not by this court, but by the domestic tribunals, the domestic tribunals have power to recall, to nullify any election. Sub-Article 2 says, the National Assembly of the partner state shall then notify the Speaker of the Assembly of every determination. That is not an idle provision. That is the recall provision. That if the domestic tribunal, which is empowered under Article 51, determines that those members ought not to be at Yala, then the Speaker of Yala will be notified and appropriate action will be taken. That is the purpose. So I wanted to disabuse the long-held notion that you cannot unswear MPs who have taken oath of office. At this early stage, I wanted to clarify that before now I proceed, my lord, into the substance of our application. Rule 87, the conditions that ought to be met have, up to this stage, I want to believe, have been met by the applicant, except on category C, which is security. I believe the issue of security is not to be determined by an applicant. It is the honorable court to assess and determine what is the appropriate security in each circumstance, whether that security is applicable and what is it that ought to be met. And we commit that whatever reasonable security that the court will determine under that provision, the Attorney General is willing and capable of meeting it. As to the first two requirements, the first issue is substantial loss. In other jurisdictions, my lord, the courts, appellate level, have just set two requirements. One, that you demonstrate you have an arguable case, and secondly, that if a stay is not granted, then your appeal will be rendered nugatory or sort of an academic exercise. In this court, however, I have not seen the requirement for demonstration of an arguable case, but I want to believe that it is a good order of business that first.
Mr. Moore, how can you make that submission? If you cannot demonstrate that you have an arguable appeal, that your appeal is just frivolous, why shouldn't the court engage with it?
Thank you, my lord. I was actually making reference to order, Rule 87.3, and that's why I was going to the exception to say that I've not seen the specific requirement for an arguable case under the rule, but I believe in good order of business that before we consider the issue of substantial loss, that an applicant ought to demonstrate that we have an appeal worth considering. Even though the rule does not expressly mention an arguable appeal, that is what I wanted to put clear, that it would not be different from what the other courts consider an arguable appeal. So I wanted to of the ruling, particularly paragraph 8 and 9, where the court has registered 18 actions which demonstrated had already taken place.
I think it will not take the election. Instead, they swear it is.
Yes, my lord.
Yes.
Thank you. The second basis, my lord, of the lame entirety of the case is that the honorable judges of the first instance division failed on ground of procedural irregularity by failing to properly assess facts that were placed before them by way of affidavit evidence and entertaining extraneous facts which were not pleaded by any party. For instance, my lord, if you look through the affidavit,
Also comment again on that.
that ground, the second ground of arguability is on procedural regularities, and that the first instance division failed to properly assess and apply facts that were placed before them by affidavit evidence by the parties, and instead entertained extraneous facts which were not in fact pleaded by anyone. And my lord, if you look at the applicant's affidavit and the respondent's affidavit before the first instance division, there's no single mention of a party called Justice and Solidarity Party. Yet, that is the fulcrus of the division that is being challenged, where the learned judges indicated that the elected representatives and some statement was made by the judges that misrepresent the character of position and party politics in shall let that statement of fact that there are no political parties in the current parliament. There are no parties. And the judges found that that was a misrepresentation. It would only mean they got their facts elsewhere, other than from their figure.
So you've gone through the entire reference.
Yes.
And the responses.
Places a case which has a strong, my lords, on the substance of whether a statement uses substantial loss. I've not come up and I'm not to tire the court into trying to define it. But my understanding is substantial loss would be a standard lower than, nugget. It does not mean irreversible as in nugget, but it would mean that it's a loss that would cause a lot of hardship to an applicant. It could involve financial difficulties. It could involve loss of opportunities in those cases. So the aspects that possible is a higher standard than what the rules provide for. But nevertheless, we are ready to argue, demonstrate that in fact, the Federal Republic of Somalia will not only suffer substantial loss, but will suffer irreversible harm if the injunction is not stayed. So allow me to argue that link as irreversible harm to the Republic of Somalia. And my lords,
Maybe counsel.
yes, my lord.
The respondents are not a part of the Republic.
Indeed, they are. But
So the respondents are also
one of the respondents,
So
one of the plea that we made before the first instance division is that actually one of the respondents is not a citizen or even a resident of Somalia. So it's contested whether all the respondents are part of the Federal Republic of Somalia. And that is an issue before the first instance. So my lord, the Attorney General's case is that these particular members have been elected to serve Yana in the current term. which is substantially depleted. That term, as we speak today, is remaining with less than 2 years of that. The term of the current year, it's less than 2 years. The MPs were elected to serve the term and not any other term. If they don't assume their seats, if they don't start their work, they would not have served the term for which they were elected. And whatever outcome that will be made, if at the point of determining the appeal, my lords determine that the first instance division was wrong, or if the references are had to their conclusion and the first instance arrives at the division, that in fact, the references do not have merit, these elected members of parliament cannot come to serve the term for which they have served. The court cannot say that you lost 7 months out of the term for which you are elected. We are now ordering that you serve those 7 months in the new term. The court cannot do that. Their term will, without a doubt, come to an end, whether they take oath of office or not, when the life of the current year ends. How possible would that kind of loss be remedied? They were supposed to take oath of office on 23rd November 2025. They've not taken oath of office. They've not started work. The term is running. That time will never be compensated. That is for those elected representatives. That's one. 2, the Republic of Somalia has never had members of parliament in parliament. This is the first time. And we all understand anxiety around the community. We understand the politics in the community. We understand the quest for representation. And in the entire composition and matrix of the EAC, it is only IALA which has elected representatives.
They say they can, the rights of the Somali people can be protected in any other organ of the community, not necessarily here.
Indeed.
When we read their submission,
Yeah.
they say the Somali people, the citizens of Somalia, their rights can be protected in any other organ of the community, not necessarily here. But there are many organs of the communities.
My lord, we don't doubt that there are other organs of the community that also serve the rest of the community within the Somali. But each organ has a distinctive role. For instance, if Somalia has a representation at the Council of Ministers of Central Committee, can those representatives go and take their seats at IALA and do debating and lawmaking? Can they? They cannot. IALA has a distinctive role, and IALA's role is lawmaking. There's no community without laws. So everything begins with IALA. The laws are made at IALA. For Somalia, representation at IALA is the core thing where they do 2 things that IALA does, my lord. And from the treaty, just flip over the treaty. IALA does 2 fundamental things that no other organ of the community can do. One, it is the principal legislative organ. In fact, it's the legislative.
Under which article?
That is Article 49 of the treaty. IALA is the legislative organ. There is no other lawmaking organ in the community. 2, IALA approves the budget of the community.
Under which article?
That is still Article 49 on the functions of the assembly. How possible can Federal Republic of Somalia and its citizens be represented by somebody who is not at the legislative organ in lawmaking or in debating and approving the budget? There's no other organ of the community which does that. It's only IALA. That is a lost opportunity. And there's no way.
But Council,
Yes, ma'am.
IALA has been there. Somalia has not been in IALA.
Yes.
the budgets have been passed and they have taken, I'm sure, the interest of the entire membership of the partner states. The legislators don't say that because Somalia is not here, we are not going to consider it in budgeting and all its activities. And the things are planned as Muslim. So why are you saying that if they are not there, the interests of Somalia cannot be taken care of?
My Lord, I would want to clarify the last year that things have run smooth. There's no statement of facts before the court that things have run smoothly without Somalia. There's silence around it, but there's no statement of fact before the court or even before the first instance that without Somalia, things have run
So
smoothly.
let us not go into politics. Let us state on
No, I just wanted to clarify that.
Okay.
That according to the Somali, things have not changed. That is why they are seeking their quest to be in their assembly. And that the fight is on the understanding that their interest has not been represented. And they really need to be there to represent those interests. But fundamentally, my Lord, that the absence of Somalia in the past was a lost opportunity. Somalia only came into the community in 2024. That is a year before this election. The process of realizing full representation in the community organs takes time. As we speak, Somalia has no member in the bench, any of the benches in court at the moment. And that is not for want of process on the part of Somalia, but on the understanding that the community processes can be slow in their nature. And so, my Lord, you understand, they are not only missing in here, they are also missing in ESJ. We don't know where else they would be missing. And that is why, for a determined process like elections, the fact that the members cannot administer representation, Somalia is already disadvantaged. It's missing in many aspects from the community organs. And this particular injunction is making their quest to get into the community even longer. I wouldn't want to say it's harder, but it's longer. That they are going to miss out from EAL for a long time, and they are really missing out. And most positions in the community, as you are aware, are term-based. Directorships, secretariats, and while Somalia might be interested in a particular one, they will have to wait for a current occupant to sit their term, and their term to end, or for them to decide. So the processes of the community are very, very slow. And Somalia is currently, by fact, which you can take judicial notice, underrepresented in the court.
maybe let us proceed with the proceeding about basis.
Thank you.
So that at least we're also not here. Yeah.
So, my lords, the main issue on nugatory assets for reversible harm is on the arguments I'm making about the fact that things that would have happened in the presence of the representatives will happen without them. IALA will proceed. IALA's business will not stop because the representative of Somalia are not there. The representative will not be given a chance to come and debate on laws which were passed when they had been elected but had not come to take care of. Those elections will not be undone because Somalis were not there. The budgets will not be undone because Somalia is not at IALA. And that now brings the question, because, my lords, you have to ask yourself, will anything that would have taken place be reversible? Is it reversible? And at page 12 of the bundle that has our skeleton conditions of authorities, we've made reference to a decision from the Republic of Kenya's Court of Appeal, Stanley Kangete Kinyanjui versus Tony Kertera and others. And the court says whether or not an appeal will be rendered negative depends on whether or not what is sought to be stayed, if allowed to happen, is reversible. If it is not reversible, whether damages will reasonably compensate the party aggrieved. So you only have two issues. Is it reversible? And if it's not reversible, and in which case we have valued that it's not reversible,
the term of the MP is not served cannot be extended. Decisions made in the absence of Somalia cannot be done because they were not there. And opportunity lost for representation cannot be undone. Can it then be compensated by damages? That is the second question. And my lords, I have tried to work mathematically on how to the judges of the Court of Appeal in Kenya considered, they said, in determining whether the success of this appeal will be rendered is a question that the learned justice asked, whether the cases are binding. They are really not binding because they are not from this court. And even from this court, your division as the appellate court of last resort. And when I look at the division by the former Court of Appeal for East African Court of Appeal, IACA, in Dodhia versus National Green Place Bank, an appellate court of last resort should not be strictly constricted by precedents. They should feel free to depart if necessary, because you are the ones making this precedent. And if circumstances present themselves, you are allowed to depart from them. So I don't believe there's one single precedent that is binding on the judges of this appellate court, even by their own division. Your divisions would be binding on the first instance division. Your divisions would be binding on the domestic courts as far as they concern interpretation of the treaty, but they are not strictly binding upon you as the court of last resort. But this particular jurisprudence was set, my lords, by one of the judges sitting in this court, and it is credible. If I found that form, and my lord, in this particular court,